Don't lecture me, counsel. I've been doing this longer than you've been alive.
So we don't know why anyone called. You might just have somebody speculating. We don't know. Somebody sees a person slumped at you're gonna call. It could be an unconscious person, it could be a guy who's been shot, it could be all kinds of circumstances. This unknown caller, Judge, doesn't have personal knowledge, can't tell you why the guy was slumped behind the wheel.
Listen to me. You're a local guy. I mean, you're just an IPSI. If your treatment plan is not doing what you need, come back and see us and see if we've got any resources we can help you with. All right? Because I don't want to punish you on this case. But if you just go out there and start doing stuff the wrong way and you don't come ask for help, then
You work for the Romulus Police Department,
Yes,
taking you back in time to October 5th of 2025 in the afternoon around 5:30. Were you working as a police officer?
yes.
Where were you at that time?
At that time, I was attached to, an address on Middle.
Do you remember the address on Bill?
I don't remember it off.
If you saw the report, would it refresh your memory? Yes, put the address on Middle Street.
Yes,
You're on red part,
please.
showing away this page 2 of the police report. Officer Gardner, just review it and tell us when your memory is refreshed.
Okay.
What is the address on Biddle?
9526 Middle.
Well, at that time, are you in uniform or plain clothes?
In uniform,
Are you in a marked or unmarked vehicle?
in a marked vehicle.
Are you alone or do you have a partner?
At that time, I was alone.
Tell us about Middle Street. Why were you at Middle Street?
We were dispatched to a male slumped over the wheel of a white Ford Bronco next to park next to the dumpster.
How much time passed between when you received the dispatch as to a man slumped over the wheel on Middle Street and when you actually arrived?
I don't know the exact time.
Approximately.
Under 5 minutes?
On that day, did you meet a gentleman named John Palmer?
Yes.
You saw John Palmer again, you think you recognize him?
Yeah.
Tell the judge whether you see John Palmer.
I did.
What is he wearing?
A gray hoodie, black pants, sweatshirt.
Noted,
Reflecting witnesses identified the defendant John Palmer.
noted.
Where do you first see the defendant John Palmer?
I'm sorry.
Where do you first see the defendant John Palmer?
He was in the white Ford Bronco,
Is he alone or does he have a passenger?
alone,
Is he behind the wheel or is he in the passenger area?
behind the vehicle.
What do you notice, if anything, about the defendant?
He was slumped over the wheel. I also observed a needle on his slab at that time.
What was that, sir?
I observed a needle on his slab at that time.
Was he awakened at any time?
After I knocked on the window, he woke up.
How many times did you have to knock on the window?
I don't remember the exact amount, probably like 2 or 3.
So what do you notice, if anything, regarding John Palmer at this point?
He woke up, took what was off of his slab, placed it to the left of him, and rolled down the window.
What did he do with it?
He took the objects that were on his slab and placed it on the rocks to the left of him.
Can you tell the judge what object you're referring to?
We recovered a capped needle and a Michigan lottery ticket that was folded up containing a brown powdery substance.
But based on what you saw, did you form any inferences as to what might have happened?
Yes.
What inferences did you draw?
At that time, we inferred that he had taken drugs and was experiencing symptoms from that.
You use the pronoun we. Who's the second person?
Officer Green responded with me.
Solomon Green. What happens to these items that you just described in Judge Holtby?
After they were photographed, we collected them and they were placed on evidence.
What happens after that?
He said their lab sheet, there's some issues, the lab to be tested.
You mentioned lotto foods.
Yes,
Do you have any experience with lotto foods in your line of work?
there are trees that typically it's used as a sword for, drugs.
Thank you so much. Nothing further, Your Honor.
Counsel, your witness.
Middle Street, what city is that located?
Right.
Thank you. Thank you, Judge.
Okay, Officer Gardner.
So you were dispatched for a welfare check.
Correct.
The dispatch related to that there had been a 911 caller.
Correct.
And that 911 caller had said that a man had been slumped over his steering wheel for several hours.
Yes.
You understood your job to be checking on this man's welfare.
Technically, Your Honor, that's not relevant. That's what she does.
She's already answered. Go ahead.
And that's reflected in your report? Yeah. And you weren't there for a fight? No. And you weren't there for any other criminal activity? No. When you got there, you saw that a man was unconscious.
He was slumped on the wheel.
Okay. Was that a yes or no, miss?
Yes.
And you saw a needle in his lap?
Yes.
And you recognize that to be drug paraphernalia? And this led you to believe that he could be unconscious due to drug use?
Yes.
And you and your partner asked the questions of his drug use?
Yes.
And you asked those questions because you thought you might overdose?
Your Honor, we would move to strike the answer of unconsciousness. She's not in a position to tell you that. She's not an ER doctor. She can tell you he wasn't awake, but how does she know whether he was unconscious?
Response.
Asking her what she observed. She can observe whether or not somebody is awake or conscious or what have you.
But it's a distinction between being conscious.
I'm not asking her for a medical.
Okay, we're going to talk one at a time. I'm sorry. Go ahead.
No, I know it's not a very important point here, but there's a distinction between being unconscious and being asleep.
I'm not asking her to make a medical conclusion, Judge. I'm just asking her what she observed.
Okay, I'll allow it. I can weed the shaft from the wheat.
And you were asking those questions because you thought he might overdose.
Objection relevancy. He either had drugs or he didn't have drugs.
What's the relevance?
Judge, I'm asking questions that fall within the statute that my client is charged under. And I'm allowed to ask those questions.
Has to be relevant, Your Honor.
Yeah.
And it is relevant.
Then explain why it's relevant.
It's relevant because this was a welfare check. Somebody was calling because they were concerned for my client's well-being. And I'm trying to gather information about what state my client was in.
Then ask her what state is your client was in. You're asking her the reason she asked these questions. Those aren't relevant. The reason she's asking her questions aren't relevant.
And would you offer my client help?
Objection relevancy.
I'm
What
asking,
matter?
it does matter. I'm asking her what happened in this matter. And how this situation ended, Judge.
What's it matter? He's charged with possession.
He is charged with possession, Judge, but it's also what he was using those drugs for. I have stipulated to the lab report. It matters how those drugs are being used.
How does that matter?
Judge, I will
Does he have a prescription for the cocaine?
not say that for cocaine drug, but it will be relevant in my mind.
Has to be relevant at this point.
It is relevant at this.
Then you have to explain to me how.
It's relevant because under the statute, there is a Good Samaritan exception to this rule.
That protects the Good Samaritan.
I'm trying to get answers from Officer Gardner to show that that was a warranted call for Mr. Palmer's welfare. And Mr. Kaplan is not allowing me to do so.
Okay, but doesn't that statute protect the Good Samaritan?
No, the statute protects the person who is using.
There's no law of that. In fact,
Yes, there is. It is.
I didn't interrupt you.
I'm sorry, I thought you were done. You took a pause.
Go ahead.
There's no law of that effect. Now, there is some case law where if you have dope, you take it to the police station, you can relinquish. In this case, he fell asleep with the drugs on his person. How does that make him a good Samaritan? He's a bad Samaritan.
May I please cite the law?
Sure.
It is 333.7403, subsection 3A. May I read it into the record?
I'd rather you hand it to me because I don't do well when people read to me.
If I may have.
Yeah.
It's highlighted.
Highlighted portion. So your argument is that Mr. Palmer's been presented for assistance by another individual?
Yes, that's correct. And it's relevant that I asked Officer Gardner if she procured assistance because that's what it was called.
Any argument to that?
How can staff?
Okay, counsel, I've asked him a question.
Anything related to this witness is hearsay. I know this is tangential. It's all hearsay. We can't cross-examine anyone who called, but it's not even relevant. If counsel were correct on this, you could have a drug kingpin who falls asleep at the wheel, and all the drugs found in his car can't be admitted. That's nonsense. There's no law about that.
Yeah, well, let's argue the language of the statute. The statute says an individual who seeks medical assistance for himself or herself, or who requires medical assistance and is presented for assistance by another, has an exemption. Her argument is because of the dispatch call, Mr. Palmer was presented for assistance by another.
First of all, we have the hearsay issue. She can't overcome. There's no doubt about it. Statement made out of court for truth of the matter certain, so we don't know why anyone called. You might just have somebody speculating. We don't know. Somebody sees a person slumped at the, you're gonna call. It could be an unconscious person, it could be a guy who's been shot, it could be all kinds of circumstances. This unknown caller, Judge, doesn't have personal knowledge, can't tell you why the guy was slumped behind the wheel.
Would you agree with me, counsel, that the reason for the call is pretty important for your argument?
I-
And would you also agree you can't establish that today at the probable cause hearing?
Check. Probable cause.
That's a yes or no question, counsel. How are you going to establish it without the person that called?
Would you like me to answer yes or no, or would you like me to answer?
I'd like to answer yes or no. Are you going to be able to establish that today?
Yes.
Good luck. How are you going to do it?
Judge, I'm trying to, again, procure answers from Officer Gardner as to why she was there, how she was able to assist Mr. Palmer in doing those things. She has answered affirmatively.
That doesn't do it though.
That she was there.
Presented for assistance by another individual. So she can't tell you why that individual called.
Judge, the purpose of this law is for.
Counsel, I understand the purpose for the law. That doesn't help us today. Today's a probable cause hearing.
Understand that the purpose also for the probable cause hearing, yes, is to establish.
Don't lecture me, counsel.
Um,
I've been doing this longer than you've been alive. I understand the purpose for a probable cause hearing. Okay? I'll allow you to ask your question.
I'm sorry. Just one. And Judge, I would like to point out that Mr. Kaplan did open the door to the 911 call in his direct examination. I did not object to hearsay to him. And he did not object to hearsay when I asked the question of what the 911 caller had
It
said.
wasn't hearsay when he used it, counsel. It was meant to explain why she went to Biddle Street. That's not for the truth of the matter.
I understand, Judge, but,
Back to your questions.
and did you call for help?
Did we call EMS?
Yes,
To petition the bill, yes.
yes. Okay,
What'd you say to what, Dick?
To petition him.
Thank you.
okay. And Romulus Police, or, excuse me, not police, fire department, they did respond, EMS came?
Yes,
Okay, and then they took him to the hospital?
yes, we're, Officer Green petitioned him.
Okay. And you did that because you believe that he needed that help?
For mental illness, yes.
Okay. Thank you.
No more witness questions for this witness?
No.
Any redirect?
Very great. Great to have them. You had other occasions where you were summoned, dispatched to an area of a person sleeping or slumping behind a wheel.
Yes,
Are there many circumstances that could cause that,
yes,
like physical illness,
yes,
like overdosing?
Yes,
like using too many drugs,
yes,
lack of sleep.
yes.
Any recross? Go ahead.
You search the vehicle, right? It's,
Action outside the scope of the finding.
judge, it's relevant, I'm just trying to lay a little bit of foundation.
But it's outside the scope.
May I approach this witness?
Sure. Morning, counsel.
Do you recall writing a report?
Yes.
And do you recall, stating in your report?
We have checked, the report is hearsay, she could be impeached if she made an inconsistent statement.
Okay.
Anything in the report is hearsay.
Do you recall evaluating whether he needed medical attention due to the state he was found in?
Check relevant.
It's within the scope of what he asked.
I'll allow it.
Yes.
Okay, and that's consistent with your report, is that correct? Okay. And so you were trying to help him, not just for his mental illness, but for the state that he found him in.
We were trying to establish if he needed medical assistance or the state he was found in.
Okay, and you determined that to be in the affirmative, is that correct?
For possible overdose, no, he did not have any medical attention for that. Medical attention was called for the petition, the comments he made while in the back of the patrol car.
Okay.
Sure.
Do you recall retaining a monitor him because he was trying to ensure that he was still alert and responsive?
Check relevancy.
Again, this is within the scope of,
I'll allow it.
were you trying to ensure that he was still alert and responsive?
Yes,
And that's because of the state that you found him incorrect.
as well as because he told us that he had used 20 minutes prior.
Okay, so that's a yes.
Yes.
Thank you.
He told you.
Hold on, hold on. How many shots we gonna have at her?
There's no redirect, but if something new is opened up, don't have a chance,
No.
maybe.
And
People are.
no other witnesses? You can step down off the guard and watch your step on my rant. Safe to assume we don't have any defense witnesses today?
No.
I'm ready for argument.
Thank you, Ron. Very simple case, happens every day, comes in any large municipality. People fall asleep in their cars. Why? Sometimes, why do people fall asleep in their cars? Sometimes they play. Sometimes they meditate. Sometimes they overdose. Sometimes they consume too much alcohol. Sometimes they're hiding. In this case, the officer responds, they see this John Palmer gentleman slumped behind the wheel, and they don't know, Judge. They acted appropriately. I mean, the guy could have been in the throes of overdose where he needed medication. We don't know that. But we do know, Judge, that he was in possession of drugs. And very interesting, brought out on recross was, he told them. He said, yeah, 20 minutes ago I used cocaine. Judge, it's possession of cocaine, not there's some perhaps at circuit court level. If so, I'm going to learn something new today. Thank you, Ron.
Counsel?
Yes, Judge. The defense had presented, Your Honor, with the statute, 333 civil force charges. So section 3A is a Good Samaritan, exception to simple possession prosecution. Judge, that exception requires that police are there for a medical emergency because of drugs. That is reflected in her report, that is reflected in her direct, testimony that the people are, quite honestly ignoring. She found a cat meal and a lotto ticket in his lap. He was slumped over not just because he was simply asleep, but because he had been using drugs. That was an inference of a drug overdose. The people had stated that, that Officer Gardner had testified that my client had said that he had only used 20 minutes sooner, but she had also, excuse me, I'm sorry. She had testified that the 911 caller had said that this person had been slumped over the wheel for several hours. It is also required that, that the drugs are in a small quantity. When I made the stipulation to the lab report, I did note for the record that it's about 1/4 gram of drugs. Less than 1 whole gram, and I'm sorry, I had sugar packet. A sugar packet, needle packet is 1 gram of drugs. Mr. Palmer had on him 1/4 of that. That is most certainly the amount of personal use. And it is a defense only to simple possession, so nothing about a kingpin, nothing about somebody who has a ton of drugs in their car. It is a statute or a law designed specifically for somebody in Mr. Palmer's situation. Police arrived because of that 911 call of an unconscious man. They find that unconscious man with needle in his mouth. They get him the medical attention. And they find a very small amount of drugs on him. And again, Judge, this is something that is designed for people just like Mr. Palmer, and as such, rule over dismissal. And I would also, I'm sorry, like to say, the Michigan Court of Appeal case that highlights this perfectly. This is People of the State of Michigan versus Justin Edward Duha. The LC number is 22. It's a published case 3115. And it's a very similar situation where in which an individual is overdosing, somebody calls 911 to get him medical attention, and the Court of Appeals found. And it is important to note that this person also said that he did not want help, or he did not want medical attention. And the Court of Appeals found that this did fall within the Samaritan exception of the statute. And if I could please present this to the court.
Sure.
Presenting the people of the patent.
Mr. Kaplan, any response?
Okay. Practicing a long time. Generally, attorneys will provide reports to the opposing attorney, so I found that reflective. That's fine. Judge, even if you find it's cockamamie claim, it's an affirmative defense, and they at circuit court would have the burden of coming forward and evidence, and then we would have to repel it, if it is an offense. But in this case, Judge, not only did he have a dope with him, but he admitted he had just ingested it. She can't tell you that any good Samaritan was calling about drugs. She just wanted to know maybe whoever called Judge. And I can't cross-examine it. I'd like to cross-examine that person, Judge. And I would ask some probing questions of them. And ultimately, you know what that witness would say, Judge? If she exists, she'll say, I don't know. I saw a guy smoking up the wheel. Thank you.
Thank you both. I'm going to bind over. Number one, I don't think it's an appropriate argument for probable cause hearing. And number two, I do not believe this is what the statute was meant to, and it does not fit the facts of the Duha case. Duha's case, the defendant's mother called after she, I just looked in and checked on him and he was not okay. He was unresponsive. I tried to wake him up and shake him, but defendant did not respond. Totally different situation than some anonymous caller saying, hey, there's a guy sleeping in a car. Bound over. AOI 7726, 9 a.m. Bond will be continued. Good luck downtown, Mr. Palmer. Exhibits and case law. Yeah. No, it's signed, yeah. Michelle, how do you say your last name? Fauser? We're waiting for your attorney. What's that for?
That was for resisting, obstructing, and domestic violence. So that was my case as well. So I think this is an early bump in the road on probation, but he's doing really,
Was he on probation at the time of the incident?
yes,
Okay. Okay.
he's doing otherwise really well.
You working? Where at?
Working at Amazon, trying to really trying to switch over feds.
he's been doing the work program. He was there yesterday. He's doing more work program tomorrow.
Okay,
He's got a probation review hearing set in July. What's what he said? July 27th.
about this charge?
I think so.
Okay,
So, Judge, we're just asking that you would accept the plea, place him on another term probation,
Mhm.
and give him the chance, at least, between now and that probation review on July 27th, to keep, checking items off
Yeah.
his list
It's with Judge Patton, just so you guys are aware.
with Judge Patton.
okay, so he's on probation with Patton?
He's on probation with Patton.
Okay, okay. When did she put you on probation, roughly?
It was 12. May as well.
May 12th?
So this was very early on in his probation, and there's, Judge.
There's something going on.
Here's
Yeah.
mental health.
Okay,
He's had to go, he just received a prescription for an antipsychotic,
okay,
and he's gonna follow up with this doctor really soon.
okay, okay,
Mom.
all right. Mom's on Wexford? Okay, okay. I'd like to sentence today if I can get something on restitution.
Me too. Figure, step in here soon.
There's a James Humphreys on it.
He's an attorney, he can answer, and I chatted him and said I think he's the wrong one, so he can say that.
So do you have a treatment plan? Yeah. Are you doing any kind of counseling, any kind of therapy, anything like that?
Trying to get into the characters, but they like out, so they were trying to like look for some.
All right. Who are you working with on that? Your doctor? Your doctor's trying to find someplace to get you in? Okay,
Or
yeah. How often you see your doctor?
okay,
So on a monthly basis?
three,
Every 2 or 3 months? Okay. Do you have any restitution information from Red Roof Inn?
Yes, sir, $2,900.
$2,900?
Yes.
Thank you. I hate to order restitution when the guy doesn't have the ability to pay for it.
Yes, sir, what at 2 years, potentially.
All right, Mr. Martin, anything else?
Just what I said before, Judge, then Mr. Brooks, he's been in touch with me throughout all of this. I represented him in the last case. He's got family support, and I'm glad to hear, he's got follow when he meets with his doctor. I think once he, nips into the mental health issues, then I think everything will be on track for him. He's expressing a lot of sincerity about, staying on his medications.
Yep.
Life is better. He's on medications. So I believe this young man has a chance to succeed on probation.
All right, here's what I'm gonna do. I'm gonna put you on probation for 24 months. It's a non-reporting probation. You stay out of trouble, that's obvious. Stick with your treatment plan. So whatever the plan is with your doc, you stick with that plan, and pay your restitution. So work out some kind of payment plan with us. Do your best on that and stay out of trouble. And there won't be any additional penalty. If you end up with new charges while you're on probation with me, then I may very well sentence you for violating probation. You understand that? All right, listen to me. You're a local guy. I mean, you're just an IPSI. If your treatment plan is not doing what you need, come back and see us and see if we've got any resources we can help you with. All right? Because I don't want to punish you on this case. But if you just go out there and start doing stuff the wrong way and you don't come ask for help, then you're kind of tying my hands. Understood? All right. Anything else?
Nothing, thank you very much.
All right. Good luck, Mr.
Mr. Mullis asked two files ending 0407 SM and 0406 ST, which are being covered by Mr. Mohammed. Mr. Mullis, can you please state your name for me?
Tony Mouse.
Thank you. You can have a seat, sir.
Judge, in regards to the DWLS counter case, I'm moving for a nullity process in the interest of justice. It's my understanding the city had prosecuted on that case already, so there appears to be some potential double jeopardy issues.
Okay.
So in the interest of justice, I'm moving to dismiss that case.
No objection?
Without objection.
Thank you.
In
As,
regards to the malicious destruction of the property case, Judge, the pleading witness was subpoenaed to be here. She's failed to appear. The officer did make attempts to serve the complaining witness in this case of her subpoena. He informed me that on 6/17, he attempted to serve her in person. On 6/18, he left voicemails on Friday, and on Friday morning, he sent an email with a subpoena explaining that her attendance was needed for this case to move forward. There was no response. So based on that, people are unable to proceed.
thank you, Mr. Roberts.
On that basis, Judge, dismiss without prejudice.
Granted. All right. Thank you, Mr. Mohammed. All right, Mr. Lecky, now your appearance.
Your Honor, Jake Levy, appearing on behalf of the people, EA000.
And again, good morning to your on staff on Roberts P. 8028. Representing Mr. Mullis on file ending 0453-FY. Mr. Mullis is to my left. You can take the vote.
Thank you. Have a seat, Mr. Mullis. Are we ready to get started, guys?
Yeah, for the record, I believe Mr. Leckie is intending to add certain charges that was like those to be noticed prior to the exam.
Yes, Your Honor. So at this time, the people are looking to add the failure to stop after collision. I don't have the MCLs right now. I'm sorry. And the license plate, registration, title, and lawful use. Like I said, I can look at the MCLs.
Okay.
But they are misdemeanors. However, I think testimony is going to come out today. Work permitted. I think that is something.
Okay. All right, ready to get started on the exam?
Ready.
Let's call a witness.
But this time, we are going to ask that officer. How to hold up the first stand.
Officer, come on up.
And officer really good for us. Here, I'm going to ask for a mutual order of seat restoration. Thanks.
Okay, granted. Raise your right hand. Swear or affirm to tell the truth, the whole truth, nothing but the truth today. Come on up here, watch your step on my ramp, settle in that chair. Holcomb, HOLC. When you're ready.
Yes, and before we begin, we are going to be offering evidence under MCL 76827C. It is the hearsay exception that allows a domestic violence incident to come in. We see that it being entered in through this witness. I believe her testimony will reflect that all the elements are met to allow that exception.
All right. Proceed.
Okay. Good morning, Officer. How are you employed?
With the city of Belleville
As what?
as a police officer.
Okay, if you could, I'm not gonna divulge your names and things. Yes, perfect. And how long were you employed in that capacity?
The city of Belleville approximately a year. Overall,
Yes, either.
overall 19 years as a
Okay.
police officer.
And what do you do as a part of your duties as an officer in the city of Belleville?
Routine patrol, which was traffic stops, responding to police runs, traffic accidents, things of that nature.
And did you respond to a police run at a 213 Aberdeen Port in Belleville, Michigan on June 1st, 2026?
Yes.
And was that, and what time of day is that?
It was in the evening, it was 21:30.
Judge, for the record, I believe Officer Holcomb is reading from a report. I just want that to be shown for the record.
Yeah.
Noted.
Going to note that.
Go ahead.
So. Now that your record is placed face down in front of you, what time did you arrive for it?
We were dispatched, I was at the location within 30 seconds of dispatch.
And Judge, if we could get clarification, you said B, so what was your reply to?
Fair enough.
Officer Pearl.
Okay. And yourself, correct? Okay. So. You both arrived at that location, what did you see when you looked at?
On my arrival, I saw some reverse lights coming out of the driveway of the location.
Okay, of what do you know what vehicle was?
It was a Chevy Equinox.
Okay, and did you at any time stop that vehicle?
I activated my overhead lights, and gave verbal commands for the defendant to pull back away from the driveway.
Okay, so you stated defendant, who is that?
Cody Wallace.
Okay, is that person? And this is the individual that you saw, right?
Objection to leading, Judge.
Sounded like it. Rephrase.
And this individual, who is that? Who's the driver?
The driver of the vehicle was Cody Wallace.
Okay, and that is the person,
Objection to leading.
and is that person in the court?
Yes,
Okay, can you point them out, they know that,
yes, it's directly behind him, jumps.
Noted.
thank you. So at this time, Cody Moss, that is the person that you stated earlier was the defendant, is that?
Correct.
Okay, so. Now. What did you see? That vehicle do?
Reversing out of the driveway.
Does it do anything else?
Came very close to striking my car, but swerved to miss my car.
So and when did that happen?
Upon my arrival,
Yes, how shortly after?
Indian.
Okay. So just for clarification. You are driving to this residence, you see this vehicle back out, and then you actually go, is that?
Correct.
Okay, what happens?
What happened next, you said?
Yeah.
Mr. Mullins follows my commands and pulls back into the car.
Okay, so down the street and then goes back into the car.
Correct.
You notice anything?
Well, Judge, advocate, I've got this clarification of the testimony. She never said that he was in the street. She said that he was still in the driveway, so I asked if that portion would be stricken.
I asked if she would pull over in the street, she said yes.
Clarify with some follow-up questions.
So what did you see in this car do? I want you to explain every single detail you saw in this car do.
So I see the backup lights as I bend the corner to get to the location. I, at that point, speed up because I anticipate him attempting to flee. When I get there, I activate my lights. He's
Where's there?
the 213 Hevery.
Okay, keep going.
I'm in front of the driveway, I activate my lights. He's still reversing, swerves to miss my car and enters into the roadway.
Okay. Then what?
I give verbal command to return to the driveway and he follows those verbal commands.
Okay. Then what?
Then, Officer Pro pulls up at that time and we attempt to separate the parties, Jennifer and Cody, to figure out what is happening.
Okay, so at the time this car pulls into the driveway, there is another individual there, you identify, is that correct? Okay, and who did you say that was?
Jennifer DeBoer,
Okay, and where was she at?
she was also in the road. On both.
What happened after that?
I then spoke with Jennifer and my partner spoke to Cody.
Now, in your conversation with Jennifer, How long after the call was that?
A minute or two.
Okay. And what did she indicate to you?
And I would object this. That's hearsay.
So this is the hearsay that we're getting in under 27C. It is a instance of domestic violence. It was shortly after this officer has indicated court will hear it that it is an instance of domestic violence, so it comes in our desk.
Anything else, Mr. Roberts?
What were that?
I'll go ahead.
So what did that individual indicate to you?
She indicated that she had invited Cody over to speak in public service.
Okay, I'm gonna
Also, know that there was an active PBO in that at the time of this. She said that the conversation turned into an argument. She asked Cody to leave. She said if you can call 911, and she said that Cody said if she called 911, he was going to kill her. She said that they had a struggle. He put her against his car, making car parts fall off of his car, and tearing her shirt, and bruising her. She said that at that point she tried to call 911 again. Cody slapped the bone out of her.
So I want to stop. So I see her looking at something.
I mean,
So I've seen what exactly she stated to you. Do you remember off the top of your head?
well, this is my police report that I did,
That wasn't the question. The question is, do you remember?
but not 100%.
Okay, so are you referring to something to,
And Judge, I'll renew my objection, so the issue here is that the statement needs to be reliable, and if she's reading from the report, I think she just testified that this is really good to read from the report, which is right next to her record. There's asked for clarity as to whether or not she can remember, and now it's, I can, but not 100%. We're straining the purpose of this rule, which is to allow for reliable testimony. I just want to renew my objection to hearsay because I don't think this is following what we're going to see at this point.
Mr. Leckie?
yeah, I was in the middle of trying to get there, but I was interrupted during the questions, but I was continuing.
Try.
Any additional information? So you can explicitly remember word for word at this moment what she said.
There's a sequence of events. I don't want to misquote this.
Well, just answer my question. No,
Question.
can you explicitly right now remember word for word exactly what she said? Okay, but on that day and that time, you did have a conversation.
Correct.
You did detail that in the police report, correct? Okay, now is that police report what you had in front? Now, if you had to, you could remember that conversation, correct?
Objection, Judge, that's speculation and it's legal.
Could you remember a conversation based on it? So, how this procedure works is if I ask you a question of what she said next, if you say, I don't remember, then we have to go through is there something that would help you remember that conversation? So is there something that would help you remember that conversation? Okay, and what is that? Okay, so take a minute, look over that. And then once you have, flip it over, and then we'll start this from the beginning, if that's fair. That's fair view, Judge.
I don't know if there's been ruling, but I'll let her.
I'm allowing it.
So you flipped your police report completely over. If your memory refreshes to your conversation with that victim that day at that time. Okay, and what did she tell you? Let's start back from the beginning to work our way, okay? So what did she say to you?
She said when she invited Cody over to the conversation regarding Wisconsin.
Okay, and then when?
She stated that after it turned into an argument, she asked Cody to leave. As she was asking Cody to leave, they ended up in the garage from the home. She said Cody pinned her against his vehicle, causing damage to his vehicle and bruising on her. She stated that she was unable to break free from that, and he pinned her against the storm door in the garage and put his arm around her neck, choking her.
Okay, and what else did she describe?
When I asked her on a scale of 1 to 10, her level of choking, she said it was 10. She couldn't breathe, and she believed that he was going to kill her.
And what else?
Stated that lasted for approximately 15 seconds.
Anything else?
After that, she said she tried to call 911, and he slapped the phone out of her hand. She yelled in the house for her daughter to call 911. Daughter came out, he released the grip from her, and she stopped the call 911.
Anything else? Then?
After she called 911, she said that he realized that she called 911, and that's when he got in his vehicle to police.
And that's where you see him next.
Correct.
Okay. Do you see anything stand out about? So you talked to her. Did you look at the car that was?
Yes.
What stood out to you about that car?
There was a mark on the rear passenger bumper door panel area, consistent with,
Objection, that I think that's going with speculation, she just over observation.
Fair enough.
Observation. What did you observe?
I saw vehicle damage on the property.
Okay. And did you see anything else of any? What else did you see?
I saw vehicle damage on a Jeep that was parked in the driveway.
Oh. And can you describe the damage?
There was paint transfer on both cars. Consistent with
Objection, Judge.
possible collision.
Okay.
So that was speculation, so the collision piece, not an objection.
Any response to speculation, objection?
Fine.
Move on.
So you saw paint marks on both cars, is that right? So one car was what? The Jeep was what color?
Jeep was black.
Okay, and what paint trade did you see on that car?
I saw silver paint on a Jeep,
Okay, and what car did you say the defendant was driving?
a silver Equinox.
Okay, and so that car was silver, as you just said.
Correct.
What color paint is on that? Okay, and was there anything else around that scene that you noticed?
There was broken parts from his vehicle in the garage from when he entered.
Objection, Judge, that is speculation. That would be.
It is.
So, without speculating, what you can only testify what your.
Garage.
And okay, now, this is just you. What did you do next with that information? Okay,
I advised the department that Cody was arrested for these.
okay, and then did you arrest? Now, when you arrest him, do you look up well, he was driving, is that right?
Yes.
Okay, did you look up anything about his car?
My partner did not.
Okay, so your partner, Officer Brooks, then. Did you look up and does that include his registration status and all of that? Yeah. And you saw those car parts, did you see even from the did you see anything else besides his vehicle reverse?
Upon my arrival, I observed the reverse lights. And I saw the reverse lights go off and him pull forward. And then him start re-reversing, and that was when I was directly behind.
Okay, so, and him being the defendant, see the solid defendant's car's reverse lights go on.
Yes.
Then go forward. Then it changed and went back again. Okay. Your Honor, I'm looking for.
Mr. Roberts, your witness.
Good, all staff, Junior Officer Holcomb, how are you doing? Great, thank you. Now, have you ever interacted with Mr. Wallace before? And that was during your time as a Bellevue police officer? You've also interacted with Jennifer before? And for this case, you're saying you had that conversation with Jennifer the day of the incident, fair to say? So of course, as officer in charge, you wanted to make sure that Jennifer could testify if she was willing to, correct? And as part of that, there were subpoenas sent to Jennifer.
I did forward her via email.
You also know that there are other cases involving Cody Wallace and Jennifer, correct? And there have been attempts to serve her with subpoenas for those, correct? You're aware that at least for the more contemporaneous cases, she was attempted service on June 17th, is that correct?
That's what I just said.
As well as June 18th.
I just said it.
Well, Your Honor, that's hearsay.
Oh, she doesn't really know. I don't mind it. If you don't know, you can just say you don't.
I just heard it in the previous,
Okay.
Understood.
So I asked to be strict.
Stricken.
So with respect to your subpoena efforts, did you make any contact with Jennifer after that day? Okay. Did you attempt to go to her house?
I think the next day. But I've been on town for the last 10 days, so.
So I'm assuming you kind of delegated that to somebody else.
I forwarded her subpoena. I shipped and Sunday, Monday night.
Okay. Any other contact that you've had with Jennifer since that evening?
One day after. I was followed.
Now, as part of this case, because it's domestic violence, you typically prepare a domestic violence report, correct?
Yes.
And that is to document your observations on the scene there, as well as document any injuries that you see on a victim, correct? And the importance of that is to make sure that even if we're dealing with the case from months away, years away, you can remember what was fresh in your mind, correct?
Yes.
And for any of those reports, you'd agree with me that you want to be extremely detailed and you want to be accurate. You prepared one of those for this case, correct?
Yes.
And I just want to go over what you noted in that report. It's fair to say, in that report, you denied that there was a PPO against Mr. Wallace, fair?
I'm not sure. I believe there was an active PPO at the time of this.
So my question is a little different. In your domestic violence incident report, it's fair to say you denied that there was a PPO against Mr. Wallace, correct? Would reviewing the domestic violence incident report refresh your recollection? Your Honor, approaching opposing counsel witness in turn with what will be marked as A for identification purposes. Page, that's so happy. Can you see the screen, officer?
Yes.
Can you tell us what this is? Is this
Speak up, counsel or officer. Thank you.
the report you prepared for the incident involving Cody Mullis and Jennifer on the date that you stated?
Yes.
Just want to review it. If you can, let me know when your memories refresh.
See that? That was probably accidental.
So to answer my question, in the report that you stated clearly has to be accurate, has to be detailed, you put that there was no detail against Mr. Moles, correct?
And that domestic violence report, correct, and the incident report,
So my question is about the domestic violence report. Thank you, officer. You also made notations as to injuries, correct? And the helpful thing about these incident reports is that there's actually a figurine where you can mark injuries, correct? And you're expected to mark injuries on the figurine so that we have a detailed understanding of what injuries were fresh from the incident, fair to say? On your domestic violence incident report, you made no notations of injuries on the figurine, is that correct?
I don't have that yet.
Would reviewing it again, refresh the recollection. Permission to approach again, thank you. With defense A for the record. And just let me know when you're ready.
Okay.
So I'll ask again, officer, on the incident report, which is supposed to be both detailed and accurate, you don't make any notations as to injuries on the figurine, correct? There's also a place where you can indicate whether there was strangulation, correct? Like checkboxing, you're not sure? Would reviewing refresh? Is that a yes?
Yeah.
Approaching with defense A. Let me know when you're ready.
Yes,
So there is a place where you can mark whether you saw signs of strangulation, correct? You did not mark that there were signs of strangulation in your incident report, correct? What you do know in your incident report is that you have somewhat of a problem with Mr. Moles.
no,
Well, you specifically know that Mr. Moles has arrest for domestic violence, but he doesn't have any convictions. So Jennifer is not here today, correct?
Right.
To the best of your knowledge, she hasn't communicated to you about the case.
right,
You're still testifying about that incident, fair? A moment, Judge.
Nothing for legal, thank you.
Mr. Lucky, oh, so you can step down, watch your step on that ramp. Mr. Lucky, before you call the next witness, are you going to call another witness? Let me take care of a plea. Mr. Duncan on Ibrahim.
Well, Judge Murray Duncan appearing on behalf of the defendant.
Good morning.
We've had, in this far, today, the date and time set for a bench trial, there's been an agreement that my client can keep going to allow an unlicensed person to operate more vehicles and to impeding traffic. A fraction would be dismissed and the driving unsuspected would be dismissed.
Thank you. Any objection if I just process one file, just dismiss the civil infraction outright and just hit him a little harder with the money on the misdemeanor? Just less work for Heather. All right, Mr. Abraham, do you understand your rights?
Yes, I do, Your Honor.
Understand the options those rights give you today?
Yes, Your Honor.
You understand the possible penalty for the added charge of allow unlicensed driver to operate?
Yes.
Understanding all of that, are you pleading guilty to that charge today freely and voluntarily?
That is correct.
Sir, did you operate a vehicle on March 9, 2026 at a location near Harrison and Cherry in the city of Romulus? At that time, was your license suspended, revoked, or denied? Counsel satisfied?
Yes.
I'll accept the plea to the added charge, dismiss both the original charges. What should I know about Mr. Ibrahim before I sentence him?
That's gonna be great for me because he's eligible to have hearing, but obviously if he's put it on his record, he wouldn't be happy.
Yeah.
So he's gonna retain me now. We're gonna go ahead and.
Good. Good luck with your license.
Thank you.
All right, you working?
Yes.
Where at? How long?
Thank
Okay. Anything else you want me to consider before I sentence?
Move forward, be more responsible with my actions and do the right thing, to go about the right process, to do what I need to do.
You don't have a hearing date yet.
No, I had to wait and see what happens.
Yeah, but he's eligible.
He don't.
Okay. What, just curiosity, time frame? How long will it take you to get in front of somebody?
Gonna get a substance abuse evaluation, so that's gonna take probably about.
Yeah.
3 weeks.
Yeah.
3 to 6 notarized letters.
Mhm.
And he's gonna fill out a form, I turn that in, and when I do turn that in, sometimes I get a hearing in 4 to 5 weeks, sometimes it's 12 weeks, it just, I think depends on how busy.
How they fall.
There's 10 hearing officers.
Okay. All right. All right, I will do fines and costs, $750, and I'm ordering 4 days on the court work program as an alternative to jail. You pick which days you want to work. We're currently scheduling Monday through Saturday. Can you pay the $750? How much is bond money on that one? Okay, so the civil infraction's already got $230 on it. We'll apply that to the $750. Can you pay the balance today or do you need options? All right, pay that today and schedule your work days. Any questions?
No.
All right, good luck with your license.
Thank you.
Sure.
I was just gonna let you know, I visited
Good to see you.
Thank you,
You're welcome, sir. You want to tell Jacob I'm ready to go? Mr. Lecky, who's your next witness? Come on up, Officer Pearl.
Okay, well,
Stands for stipulation? Just hang out right there.
so stipulation 2 is. Invalid license. That the license plate he was using was not his, it was from a Ford F-150. The license plate on this vehicle was a license plate to a Ford F-150, not the.
And he wasn't driving an F-150.
And that his license plate registration and insurance were all invalid.
Solely for the purpose of exam, I don't want to say stipulate because it's still Bruce, but I would not object to those being part of the final argument, and I will not make objections as to those being.
Is that helpful? I'll put him on.
That's,
Your call.
Your Honor, for my door as to the additional premise to the grade.
Okay, we don't need you. Okay. All right, so no other defense or no other prosecution witnesses, correct? Defense putting any witnesses on? I'm ready for argument, guys.
One, which is all we're here for an exam today.
Yep.
We testified based from a officer who heard from the victim of the victim. As we heard testimony, that statement was a domestic violence or a summary of a domestic violence incident of a threat or physical force. It was made in a timely manner, so it is credibility, it is credible. I believe she indicated that she was strangled. It was a rating of how strong the strangulation was, from 1 to 10 as a 10. She did say it was pretty. Therefore, I think count 1 we consider the other reasonable doubt, at least for purposes of the exam. Now, count 2 and count 3 we just follow. For the additional count 4, the failure to resist collision, we heard testimony that there was some broken car parts and there were some paint trading. The officer did describe that the defendant's car moved forward and then moved backwards. Moving forward was the car in the garage that was hit. And he failed to stop after that collision and instead driving away until he was stopped by the officer. Once he got into the roadway, but for the officer showing up, would have driven away. And by driving and backing away and getting into the street, I'm going to argue that he did drive away after that collision. Now, for failure to stop after the collision, it doesn't have to be at a highway. It can be in a personal place or a residence. So we're alleging that the collision happened in the driveway, in the garage. That jerk motion was him hitting the car, realizing that he wasn't driving. He then backed out and took off. But for the officer showed up, he would have. Now, we also stipulated to the license plate that was on his vehicle, that he did display on his, whatever the vehicle type, but
Equinox.
the was belonging to a Ford F-150. That is the license plate registration title. It was a license plate not made or not for his vehicle that was fixed to his. Therefore, I think you have mind over on those 2 additional.
Thank you, Judge. With respect to count 1, there has been no credible evidence of strangulation, Judge. This officer indicated that shortly after this incident, she prepared a domestic violence incident report where she's supposed to document injuries that she sees, signs of strangulation. Strangulation is so common, Judge, that we make it part of the name of the GBH statute. Officers are trained to recognize those signs, certainly to take a narrative, which she did, but to recognize those signs. She states very clearly, she made no notations as to injuries observed at all on the body. If someone's being strangled for 15 seconds at a 10, Judge, there's going to be bruising at a minimum. We didn't hear any indications that there was loss of consciousness, difficulty breathing that she observed, and she arrives 30 seconds after this is supposed to have happened. So it's not just shortly after, it's basically immediately after. To see no injuries, to not notate that there's any indication of strangulation. There is not, even at the probable cause level, enough for strangulation. Her narrative will maintain our objection as hearsay. But with respect to count 2, which is domestic violence, Judge, if Your Honor chooses to credit the narrative of this officer, sure, there's enough for domestic violence. I mean, I'm not going to make a useless argument. But I think really the misdemeanor counts are what remain here, Judge. If there's strangulation, there would be signs, and this officer, I think, is obligated to notate those if there is some sign of that. And Jennifer's not here to give her side of the story, which I think should also be considered with respect to the reliability of that narrative. There were at least some attempts for a subpoena. She's not here. I won't speak out of the record as to other subpoena attempts, but for this case, she was subpoenaed. And, they have to show some proof of strangulation. And if it's not through Jennifer being here to say what injury she had, it would have to be through this officer observing something. And there is a fact. So for that reason, Judge, we're asking that count 1 be dismissed. If Your Honor credits our hearsay objection and ask that count 2 be dismissed. Otherwise, I think the rest is misdemeanors and would be settled here.
Thank you, Ms. Velicky.
Mr. Honor, so I think it's important also that most of the bruises don't show up immediately, and they don't multiple bruise differently. I'm sure we've heard multiple testimonies throughout our years doing entirely now, that everyone was. So I don't think we can consider that. Also, there's no requirement by the statute that there has to be sign of approved, there has to be sign of an injury, it just has to be that the mode was done by strangulation or suffocation and that being assault. And we heard testimony that it was for about 15 seconds and it was, she had a heart attack. Your Honor, I think it might have been by the word.
I agree. It's a probable cause hearing. I think the officer's testimony about what she was told at the scene by the alleged victim is enough to bind it over. So I will bind over on count 1. And as we've all said, everything else just tags along. AOI date's going to be the 30th, 9 a.m. Anything as to bond, gentlemen, or should it stay the same?
Well, I guess.
Bond will be continued, and Mr. Mullis, good luck downtown. Oh, Mr. Mullis, just to let you know, I know you're not in a position to do it right now, but you owe us $1,000 plus on various things. We're gonna need some kind of payment plan at some point. And I just made, I didn't do the statute, I just made it. Yeah.
Thank you, Judge. Thank you, Madam.
Hey, Mohammed. While you're out there, would you tell the attorneys on Lemke I'm ready to go? Thank you. Have a nice day. That's yours, Jacob? Stay safe.
That was nice to meet you.
Yeah.
John, Mark stood that
What did you?
about saying, I just stipulate, you don't need to.
Oh, yeah, absolutely. Yeah. Yeah, come on up. We can hold? Okay.
Wait, but,
Yeah, I'm ready. Go ahead and put your appearances on the People versus Lemke.
Good morning, County Satchel, 85689. Somebody can stand out and say your name to the judgment.
Thank you. Go ahead.
Your Honor, I do a competency evaluation in my conversations with my client. He had told me that he both had injury and traumatic brain injury in the past, and in speaking with him and usually with his daughter also hasn't, it's become clear to me that he cannot recall our conversations, in between.
Yep.
So it's a matter of something that we talked about yesterday or on Friday. Can't remember, and that on the second prong of competency, and in particular, the ability to effectively communicate with counsel and gain one's own defense, I have some pretty real concerns about that factor. So I would ask that you forward a competency evaluation.
And normally, Your Honor, I wouldn't have an issue of any kind of deterrence or anything as to that. However, our victim, we flew in from Florida. She is here, she's present, she's ready to go, we're ready to go. I think, and unfortunately, I wasn't here last week, but I did leave instruction that she was gonna be coming from Florida and we needed to make sure this was going.
That was not shared with me. Whether or not it was shared with counsel, I don't know.
And that's a part of what we mislaid the machine. However, our issue is she's here, we're ready. I know counsel and I talked about possibly, well, we can discuss that, if you'd like.
I agree it's unfortunate, Your Honor, but I was unable to contact Mr. Leckie about this previously because I really had to see if my client could remember our in-depth conversation about this matter from Friday. Because to me, that was going to be the test of do his issues from this TBI, meaning that I am in a space where I'm concerned about competency to a bona fide degree or not. And maybe, you remember a pretty in-depth conversation about the case today. I didn't really tell beforehand if this was something we'd be able to work around, but at this time, I'm not comfortable moving forward without somebody who knows a lot more about the brain and.
Right. Anything else?
Just, briefly, I will note that the competency And the Michigan Court Rule, the MCR, requires that this be timely. Granted, it would have been nice to give us some lead time. I understand that today the conversation had, she wouldn't have known. Just for the record, no, I guess I wish it would have been more timely. I understand that it couldn't have been. And for the complainant sake, I mean, we are ready. I know we could possibly hold the complainant, however, if the defendant is not able and they make the determination in competency that he was unable to participate in his defense, then it won't, it's not even going to be worth it for the confrontation clause of this. So, Your Honor, I guess we object, but understand.
So to rub salt in the wounds, if I would have known last week that the victim was going to be flown in from out of state, I might have suggested another PCC because I knew you didn't have much contact with your defendant. I have to order the competency, and I will be happy to talk to the complainant if you want me to and apologize for the waste of time, but we need to order a competency. So I will do that. All right. Anything else? Counsel, I'll hang it.
What's going on?
I'm assuming we haven't had any problems since last week. You haven't heard about any problems?
Is there issues on?
There haven't been any of the further issues, Your Honor, and I've spoken with the family now, and I think that
Is his daughter here today?
she is not here today. She had to work. She is in the Zoom waiting room, Your Honor, because she's.
Okay. Is she still there? Bring her in. Miss Lemke, are you there? Carrie,
I am here.
you want me to hang on to this phone?
Due to a transportation issue, it would be greatly appreciated for future travel if we could get it back.
I'll
If
provide
I
it to
have
counsel.
to monitor it, I will.
Please do.
I will.
All right, good luck.
Thank you, sir.
All right, anything else?
No. Thank you.
Is he staying at that address?
With his daughter, yes.
The one, I just need to know so that whenever I order the competency.
Yes, that is the address, the one from the BCC with his daughter. That's
Yeah.
still in the.
I can write it down.
It's in there,
You got it.
whatever address we have.
We should be good then.
Thank you.
You want to get it again, just to be safe?
Speedway Drive Show. Township.
Yes, that is.
Oh, all right.
All right.
You'll be receiving notice in the mail.
Thank you.
Lieutenant, did you see your email from me? Yeah, that was not, I'd like the changes.
Yeah, I'm about to give you a call.
Well, yeah, but I was trying to figure out something else to fill the plaques, so yeah. Yeah, so we'll see what kind of feedback. No, we'll see what kind of feedback we get.
We don't say.
This courtroom hearing quickly turned into a tense legal showdown as Judge Oakley clashed with a defense attorney over the limits of the law and courtroom procedure. The case centered on a defendant who was found slumped over the steering wheel of his vehicle with drugs allegedly in his possession. The defense argued that the defendant should be protected under Michigan's Good Samaritan law because someone had called for medical assistance after seeing him in distress. Their goal was to convince the court that the evidence should be dismissed under that legal exception. However, the prosecutor strongly disagreed, arguing that there was no proof the anonymous caller knew the defendant was suffering from a drug overdose. Instead, the caller may have simply seen someone asleep or unconscious in a parked vehicle. That distinction became the heart of the legal debate. As the attorney continued to explain the defense's position, Judge Oakley grew increasingly impatient, delivering the now viral line, "Don't lecture me, counsel. I've been doing this longer than you've been alive." The exchange highlighted the judge's insistence on staying focused on the legal standards required at a probable cause hearing rather than broader policy arguments. After hearing both sides, the judge ruled that the Good Samaritan defense did not apply at this stage of the case. He concluded that the facts were significantly different from the previous case cited by the defense and ordered the case to move forward. The hearing served as a reminder that courtroom arguments are not only about the law itself, but also about presenting evidence that fits the legal requirements. Even a well-prepared legal theory may fail if the supporting facts don't meet the court's standard.